Hello, I'm Juban with Dana Legal Services, and in today's video we're going to talk a little bit about patentability searches. A lot of my clients ask me about patentability searches and they're wondering what they are, should they do them, and things like that. So I'm hoping to address that in this video today. By the way, at the end of this video, if you like the content and you want to help us out, just like and subscribe. So taking a look at patentability searches, first let's define what they are. What are patentability searches? Essentially, a patentability search is a search you do to determine if your idea has been previously disclosed and therefore you might face issues when it comes to patenting the idea. In other words, you might face issues when you go to file the patent application and then the patent office will reject your patent application because your idea has been disclosed. All right. So taking a look at what you would search or what databases you would search is what determines the scope or the extent of your patentability search. The main thing that people do is search the U.S. Patent and Trademark database for issued patents or pending patent applications that are made public. Now keep in mind that not all patent applications are public, and patent applications have to be pending for at least 18 months before they become public. So it's quite possible that you'll search the Patent Office database and the patent application that might be of relevance to your idea is not yet made public, so you won't discover it until you file. The other thing is you can expand the scope of your search beyond just the Patent Office, because the examiners at the Patent Office can use any source of public information. In other words, they can rely on newspaper articles, they can rely on website publications, they can rely on technical magazines, they can rely upon technical journals. So anything that's made public, the Patent Office can use against you. So what a patentability search is doing is trying to determine if any part of your idea was made public, and therefore would be something that the Patent Office can use to determine if your idea is patentable or if they're going to be able to reject your idea based on a public disclosure. They call that prior art references. Keep in mind also that a patentability search increases in cost as you increase the number of databases that you want searched. So if you're just searching one database, the cost is lower compared to if you're searching multiple databases. And also keep in mind that once you get the results of the search, you will need to review those results to see their relevance to your idea. Now, I strongly recommend that you have someone who understands patent law, in other words, a patent attorney or a patent practitioner, take a look at the references that have been uncovered and give you feedback as to whether or not they're relevant with respect to your idea. Because at the end of the day, the Patent Office will look at the claims of your patent application, and based on the claims of your patent application, determine whether the references are relevant. So you do need someone that understands how to read claim language and look at it. Roughly the cost of a patentability search should be anywhere from about $1,500 up to about $6,500 to $7,000. It again depends on how many databases you search, how much information is disclosed or uncovered. Another question that's often asked about patentability searches is, should I do one? That's a mixed bag of goods, and I'll address that in another video, but essentially it's entirely dependent on you and your budget and your expertise in the field. The other thing I want to make clear about patentability searches is that getting a patentability search done is not necessarily a guarantee that you'll be able to get a patent or that there'll be no issues with your patent when you file it with the Patent Office. Because keep in mind two things. One, some applications are not yet made public, but they could become public shortly after you file it, in which case it can be used as a reference against you. Also keep in mind that an examining attorney, an examiner at the Patent Office will have their own interpretation and their own way of interpreting your claims. So therefore, they might come up with a different analysis than your patent attorney came up with. However, doing a patentability search does give you some perspective as to whether or not your idea has been disclosed, has been covered, or is already out there. So again, back to the question, should you do a patentability search? That's entirely up to you. What are the costs of patentability searches? They can range anywhere from about $1,500 up to about $6,500, $7,000, depending on how much information is searched for and how much information is related or relevant to your search terms. And of course, when you do a patentability search, you have to come up with some terms or some key phrases that are related to your idea, which is the basis on which the search is implemented. Finally, the one thing that's really important about patentability searches is to keep track of all the documents that you review, whether they're issued patents, published patent applications, or articles in a journal. Just keep track of the reference, because you do want to disclose these references that you find in the patentability search to the patent office at the time you file your patent application. Thank you for listening. Once again, my name is Jubin Dana. We're here to help you. So if you have any questions about patentability searches, give us a call. We're happy to provide some answers. Take care.